Good afternoon. Welcome to Long Live Third Parties Podcast. Free Press Media Press Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Libertarian Party versus District of Columbia Board of Elections and Ethics, 682 F3D 72, Court of Appeals, District of Columbia, Circuit 2012. Friends, another issue for us to appreciate. We are here to appreciate third parties because third parties rock. This case involved our friends at the Libertarian Party, particularly their candidate Bob Barr, who ran as the presidential nominee in 2012. In this case, they were trying to get the write-in votes counted. Unlike other cases, they did get access in this case. They had access in the District of Columbia as a write-in candidate. So that part, fortunately, they won. So good job to the Libertarian Party for getting on the ballot in the District of Columbia and all the other states who got on the ballot in that election. So what happened here? Let's read from the record. It says, quote, "The District of Columbia's Board of Elections and Ethics published the total number of write-in votes cast in the 2008 presidential election, but consistent with its regulation, never reported which individuals were penciled in by voters choosing the write-in option or how many votes any such individual accrued. The Libertarian Party, along with his 2008 presidential candidate Bob Barr, write-in candidate, contends that the district's failure to report the numbers of votes cast for Barr violates the First and Fifth Amendments." End quote. Getting back to what I said earlier, it's the 2008 election for Bob Barr, not the 2012. This is the first time I've seen someone invoke the Fifth Amendment. Like I've been saying again and again, often I see them invoking the First and 14th Amendment, which we love. So we love him invoking the First Amendment, and we also love the Fifth Amendment. I like the whole Bill of Rights. How about you? So what else happened here? It noted in the District of Columbia, he was able to be a write-in candidate. And he got an undisclosed amount of votes. They were talking about how the Libertarian Party wanted to know exactly how many votes. It says, quote, "A total of 1,138 votes were counted as votes for write-in candidates," end quote. And, quote, "But because the total number of write-in votes was not sufficient to elect a write-in candidate, the board, pursuant to Section 806.13 of its rules, did not individually tally and report the total number of votes cast for Barr or any other write-in candidate. The Libertarian Party, Bob Barr, and several citizens who voted for Barr sued in the United States District Court for the District of Columbia, alleging that the board's failure to do so violated the First Amendment speech and associational rights and their Fifth Amendment equal protection rights." End quote. What do you think, friends? What do you think? Do you think the Libertarian Party and any other party has a right to find out how many votes were cast for their candidate for a write-in? Do you think that's unnecessary? This is an issue I never considered before. I would like to see how many their candidate got. Unfortunately, the other side had arguments against this. The Libertarians here were arguing it helps them to know how well their candidate did so they can use that to access their strategy in the future. Also, the voters have the right to know because they have the right. And also, it helps the administrative process because it determines whether they qualify as a party. The judges here said it's essentially a non-issue because even if they got all the write-in votes, it still wouldn't be enough to qualify as a party. They were saying here, quote, "Like this one where write-in votes could have no possible effect on the outcome. The district's refusal to tally and report the precise number of voters who penciled in Bob Barr as their candidate of choice hardly amounts to disenfranchising those voters, or more precisely for our purposes, imposing a severe burden on their rights. End quote. The judges also say the Libertarian Party is able to access the information via Freedom of Information Act, so they can examine that. So do you think that is justification for this? Do you think the Libertarians have no case? Hopefully not, but maybe you do. These are things I haven't considered before, as every one of these cases has different nuances here. So I could see how they want to know. The Freedom of Information Act, although that's better than not having it, it may not be enough, and it may not be within their rights. So ultimately, they ruled as follows, quote, "We affirm the judgment of the district court," end quote. Friends, the Libertarian Party challenged another aspect of election law as pertaining to ballots. They got on the ballot, fortunately, but part of getting on the ballot is wanting to know how many your candidate got. You want to know your success. You want to know how well you did. Makes sense to me. They argued they need that information, so it's wise to give that information to them. They did a good job fighting this fight. Way to go with the litigation. We like to see that litigation. Long live third parties. Goodbye.